Hi everyone, I'm Ross McCrae, Group HR Director and Deputy MD at the Orion Group. Welcome to our presentation series on off-payroll working. This is number 2 in the series, and in this presentation we'll cover a number of the key criteria that are used to determine whether a contract worker is self-employed or not. Our overview of self-employment status tests continues in the third presentation in this series. The revenue require an evaluation framework to assess whether a subcontracting worker is engaged as an end user's employee for tax purposes. This was compiled over 20 years ago, primarily utilising a range of historic self-employment tests that were established through case law during the decades before. Many of the key status tests are related, and some carry more weight in assessment than others. We'll start with the practice of transferring from staff to contract with the same company, as the legislation was initially established to counter directors, particularly in the IT sector, finishing as staff on a Friday and starting as a subcontractor on the Monday, solely to increase their income through tax and national insurance avoidance, despite carrying out the same role at the same company. It's highly probable that this act alone will instantly class the contract for service as retained employment and therefore in scope of IR35. As a minimum, there should be a break in service before working for a former employer, and any assignment undertaken should be fundamentally different to the role undertaken when staff. HMRC places a lot of emphasis on the feel of a client-contractor relationship. It's difficult to measure, but they sum it up as assessing whether the contractor's worker is part and parcel of the organisation. They are primarily considering whether the contractor is integrated into the client company. This relates closely to mutuality of obligations, control, and employment benefits, which we'll cover later. I have some examples detailed on the screen, including having a car parking space, being documented in staff organisation charts and such like. It's pretty obvious that these types of provisions should be avoided, but the situation is less clear when it comes to things like being provided with a desk or a workstation or even an office, having access to particular systems or networks, appearing on internal telephone directories, perhaps appearing on client websites, or having your own company email address provided by the client. Now, there might be natural justifications for some of these arrangements, including convenience and access to proprietary systems, but I'm sure you can understand why the revenue view it as unusual that an employee of a third-party company is so closely associated with the end user. For self-employed status, you'll want to minimise the number of such challenges open to the revenue. Engineering and technology sectors tend to be mobile industries, and it's not unusual for end users to book flights and accommodation for workers of their suppliers. Again, there are reasons for this relating to convenience and cost, but for a revenue inspector you can appreciate it's seen as unusual for a client to be making such arrangements for an employee of another company. Individually, all these factors may not determine a status review one way or another, but combine a number of them together and it's likely to suggest that the worker is not operating independently of the client and indeed is part and parcel of the business. Turning now to supervision, self-employed subcontractors should not work under the day-to-day control of their client. It's as straightforward as that. It's essential that they determine how their work is carried out, where their work is carried out, and when their work is carried out. There's been tax cases going back to 1973, for example, Fall versus Hitchin, that state self-employed personnel who are obliged to provide services under precise instructions or control are classified as employees. How the activity takes place should also be at the discretion of the contracting company. Contractors should not be told how to carry out the project that they've been engaged to carry out, otherwise it demonstrates client control. So for genuine independence, contractors must be able to decide where and when their staff carry out work and who schedules it. In the ready mixed concrete versus Minister of Pensions case, control was found to be the power deciding the things to be done, the way in which it shall be done, the means to be employed in doing it, the time, when and where, the place it shall be done. Work carried out at a client site or office is appointed towards being inside IR35, as it implies control as to where the work has to be done. However, the revenue is aware that they should be careful about making a judgment concerning status where the nature of the work dictates where it should be carried out, the point being that certain activities can only take place at certain locations. In such cases, the factor is not likely to be of significance in determining final status. For working hours, fixed hours typically points towards being inside IR35, but it depends on who sets the workers' hours and why they have been set. So for example, there could be security issues relating to worksite access or when a building closes, or if working on a large site where access is limited to normal working hours, the worker is not going to be able to work as and when he or she pleases. In such circumstances, the limitations put on when the work can be carried out says nothing about the tax status of the individual, and other factors would have to be considered. Just as subcontractor workers shouldn't be managed or supervised by clients, they also shouldn't be seen to manage or supervise the staff of their client, otherwise they may be identified as being part and parcel of the organisation to which they're providing services to. It is, however, perfectly acceptable and a legal obligation in some instances for various safety and qualitative checks to be carried out by the clients on the works undertaken by subcontractors. That should not be construed as supervision or control, and it is quite distinct from a manager setting and controlling day-to-day activities of contractors. Retaining the right to substitute a worker is one of the strongest demonstrators of self-employment and is assessed in every case review. A contract for completion of a defined project is a contract for services and is not based on the provision of a specific person. The agreement is for the provision of services. So a right to substitute means that the personal service of a specific individual is not required and therefore no contract of employment is present. Securing approval from an end user to use a substitute contract worker does not inhibit the right of substitution. Ruling out a substitute on the basis that his or her skills aren't suitable is just a quality control matter. The fact that both parties have to agree that a substitute is able to carry out the work does not point towards deemed employment. So, truly self-employed contractors should have the right to substitute their workers. Does not mean that they have to apply substitution, but they should certainly have the right to, should they wish. It goes without saying that substitution has to be real and not just seat swapping between subcontractors, as that is not genuine working practice. Authentic substitution would involve the provision of a replacement worker who does not already provide services to that particular client. That brings to an end the first part of our review on employment status test. It continues in our third IR35 presentation.